All right, we are recording. We're here for CBA 23-015, Owings Mills Commons, 10246, Reisterstown Road, applicant Floor and Decor. This was an appeal from an 11/9/2022 decision by the DRC granting a limited exemption pursuant to BCC 32-4-106 B8. We heard a little day of testimony on this situation. I think we heard from Mr. Moxley, the chairman of DRC, as for his rationale for granting the B8. We heard from, I think, Mr. Bishop, the land planner, and I think the actual protestant himself testified briefly at the very end of the hearing. Mr. Evans and I had been on a prior case that was basically in the same locale, so we were very aware of the area. The proposed plan is for an existing structure. And Mr. Sampson, he was familiar with the property, referencing purchasing iron-on patches for his jeans as a youngster.
Indeed, sir.
Well, I think in our prior case, it was
the protestant's development.
right. It was the protestant in this case.
Yes.
Was I think it was Lion Brothers that was objecting to this protestant's Valvoline.
Yes, it was Pizza Place to Valvoline.
Right.
And it was
Right.
Mr. Holzer.
Right.
And we talked a lot about, and that was Mr. Patton telling us about the history of public and non-public roads and things.
Right. Right. The question was, what's a street?
What's a street?
Yeah.
Sometimes you got to refresh yourself. What exactly is a street? There you go.
Right. And I think actually Maureen Murphy wrote the opinion in that, I think.
Think so, perhaps. So as is the case in most of these limited exemption cases, we're going back and looking at 32-4-101 AA in the definitional section and deciding what a minor development is. And then more specifically, we're going to argue whether or not there's a public works agreement pursuant to the A1, or if it's one of those A3s where, they can deem them to be minor improvements that doesn't require anything further. Just as a refresher, when you have the B8, you have a development plan, but you have it reviewed administratively. You don't have a hearing officer, and you don't have the community input. So that's the B8 version of the abbreviated development process. So the first issue here, facts-wise, when you say development, we're not building a new structure. We're using a previous structure in a shopping area that had previously functioned. And there had been some discussions as to the stormwater management and other things that were going to be on site and whether they rose to the need to have a public works agreement. I do recall, Mr. Moxley, we kind of finally figured out that in the county process, the determination of a public works agreement usually occurs after an exemption has already been given. So it's kind of like a chicken egg type of thing. So we basically had to figure that out on our own. So that was our first issue. Does anyone want to take the floor in discussing whether or not the facts that we heard from Mr. Bishop and Mr. Moxley concerning the improvements that are going to be needed to this existing site raise to a bar that would make it not a minor development pursuant to 32-4-101 AA? Anyone want to chime in before I do?
Just one point of clarification. I thought the building that the former Lion Brothers, where Mr. Sampson got his iron-on patches, I thought that building had been raised.
I think you're right. I think you are right. It's
So
just,
it's a vacant lot at this point, I think.
it's the same location, but there.
Same location,
right.
but I think there's no build, there's actually no structure there.
I misspoke. The patch place is no longer there. So we have, we're
Right.
gonna put the new place for this. Yes. All right. That being said, again, I'm sorry for that mishap there. Anyone else would chime in before I chime in? I'll just chime in quickly since I'm already
Okay,
talking.
all right.
I seem to do that a lot.
Yeah.
Basically, to me, in this situation that we're dealing with a commercial area, with the curb cuts are the same, the place is the same. The stormwater management, to me, this seems to be a necessary. There was no evidence that I heard that I thought took it beyond what would be contemplated in the pragmatic sense of a minor development. Again, in getting details as to when a public works agreement is needed at one point in time, there was some confusion from Mr. Moxley about when this is decided, but sometimes in these situations, I will defer to the expertise of the county of how they administrate these things. And based on the fact that it is a commercial setting, this is not a residential development. It's something that is basically has been there. We're just replacing it with something else. I'm still convinced that the B8 still applies. So that's what I say.
Well, actually, I agree. I thought it was, there's it can't, one of the disjunctive requirements is that if the director finds it's minimal, then doesn't that trump everything as well?
Yeah, that's the A3 is that you
Right.
have one is so you have the public works agreement, then if you get around that, if they say the things are minimal, which is
Right.
a great term of art for us to apply.
Well,
in
it's a
this
huge
sense.
term of art because you don't think of building a big building like this as being
Yeah.
a minimal improvement. But, and the director did in his director's letter, I went back to look at that. He did. I mean, this is as an aside, if one, it occurred to me in a fairly sort of pinheaded, esoteric moment that even though our review is de novo, the statute says that the director has to find that it's minimal. So I don't know that we could have found, if he didn't find it was minimal, I don't know that we could find it's minimal, even though our review is de novo. But fortunately, that's not an issue here because the director's letter does find that it's minimal.
Yeah.
And I think I agree with that. As it's not intuitively obvious that building a building like this would be minimal. But if you look at what the statutory definition of minimal is, then I think this basically does fit in that. I was on another case where minimal, we had to construe what minimal landscaping meant. And since virtually every case that, since the beginning of time for Baltimore County has required some landscaping, we decided that planting some trees and some shrubs and, some things like that, that's really not the kind of landscaping that's contemplated in this particular provision. I mean, the landscaping here would be grading and putting in swales and I mean, all kinds of things other than just adding some vegetation. So I would find that it's minimal. I would also find we've had cases where public works agreement references were in the director's letter. So, and I think the Jacksonville case is the most notable one, right? Where the letter actually referred to the possibility of public works agreements,
Yeah,
and this letter does not. So even taking into account what Mr. Moxley said about how it might develop later, that one's needed, at least at this point on this record, there's no public works agreement contemplated. So I think, so I'm good with finding, finding it, the B8 exemption applying for those two alternative reasons. That would be my view.
all right, Mr. Sampson, anything to add, sir?
I would just add, I think on that minimal term, it's minimal public improvements. And part of this reason that Mr. Evans points out, it seems like it would be much larger in scope and not minimal. I think may have to also do with the fact that the private nature of much of what is involved here, as opposed to public. Just to be able to add something. That's all I have to add.
And thank you.
Thank you. And I do recall too, the testimony of the brief testimony of the protestant in this matter, I believe referenced concern about an alternative exit entrance in the back of the site that had been brought up in the previous case, which I don't think was germane. It's kind of basically a Greenspring, Meadows of Greenspring Foxley type issue. It's like we're not delving into any of those things other than issues just with the B8. So based on that, I think we're unanimous that the B8 does apply. Now the more interesting, well, I'm not saying big issue, but interesting issue was Mr. LaFiandra did a fantastic job of bringing to attention the new requirements of Bill 5122 regarding postings on the website for applications, decisions, and then the written decision itself in a time period that he was able to show us in real time, obviously had not been complied with. And I believe Mr. Moxley said that he agreed that it had not, and basically the county infrastructure had not caught up with the legislation as to what was required. So I guess our question for that issue is it germane to the granting or not granting the B8, and whether or not it created a prejudice that would be taken into consideration in this matter. As for my thoughts on the matter, I think the legislative purpose of those things is a notice, and for community notice and just notice of anybody who would want to oppose the limited exemption. As noted it by the petitioner, evidence of effectuated notice would be the fact that council was present making such learned arguments to begin with. So I believe notice was there. There was substantial compliance. Not to say in the future, if we have one of these cases that we often had where we're fighting about the day that the actual appeal was due, this would be a very germane situation if there then was a statutory requirement for posting, and we were arguing about whether or not someone's appeal was timely. And we have had that matter on several occasions now. And I think in the future, those might go the other way now that we have a bill that makes requirements of certain things for certain type of cases. But other than that, I think this is substantial compliance with notice provisions did not create any prejudice that this board has to consider at this time. So that's my thought on that matter.
Well, I also agree with that. I mean, if there was any error, it's harmless. It's just another way of saying that there was substantial compliance. The protestant knew all about this. This is a sophisticated protestant, and with sophisticated counsel. And so I don't think there's any actual harm. The one thing I do want to say, I was completely unsympathetic to the notion that the county has had trouble complying with the law. Okay, that just doesn't cut it for me at all, at all. That's not an excuse. And in a different case, I would say that straight out in writing. But this isn't the case for that. Doesn't really matter here. But it would behoove the county to take steps to come into compliance and to learn how to comply with the law. That's really, I mean, and my sense for Mr. Moxley is they really weren't doing anything. They really weren't taking it seriously. I find that, to me, who spent most of my career in government, I find that shocking. And I find it, I find it imperious and high-handed. So.
Mr. Sampson, what do you say, sir?
Well, just to be heard on a recording, I'll say that I find that notice is critical. I think the bill is important. We need county transparency and public confidence restored, upheld, furthered, and notice accomplishes that. So in this case, depending on one's perspective, whether it's fortunate or unfortunate, I do think nonetheless, substantial compliance, but also actual notice cures it in effect. The intent of it, the intent of the bill and the notice, while not fully complied with, still resulted in the fact that the protestant was able to advance its view and be heard. And that is why, as you said, Mr. Bell or Chair Bell, that's why we're here. And Mr. LaFianza did an outstanding job with what he could, but the application of law and facts in this case under the foregoing analysis is why we're going to grant the relief. But this is an important issue that he raised. I think you are 100% correct, as is Mr. Evans, that in the future, the county's on notice, if it wasn't already, that it better get these things posted timely and fully.
Well, and Developers Council, that has ongoing interactions with the county on all of these matters. And so it would probably be useful for council in these matters to nudge the county, to encourage the county to get the notice right, because if the county doesn't get the notice right, the loser here isn't the county, it's the developer. So that's who's going to incur the expense of non-notice. So, that's something I think all counsel for developers should keep that in mind.
All right, well, I believe that concludes the two major issues. We are unanimous in our de novo review of this matter and have found that the limited exemption pursuant to BCC 324-106B8 shall be granted. I will volunteer and write the opinion. And as for this deliberation being Mr. Sampson's last visit with us, I'd like to thank you very much for your service and that your contributions to this board over the last 3 years have been professional, intellectual, and learned, and we have benefited from you being part of our bizarre little old man club and old
And old woman club.
yes.
Well, I appreciate that. I have learned tremendously from you, Mr. Belt, you, Mr. Evans, former Chair Dockin, and I learned just enough in the 3 years to now have to rotate off of this board. I am probably at this moment the most confident in understanding whatever it is I'm ever going to understand about this. I think it should be longer terms. I think it should be full-time. And what you two bring to it and Chair Dobkin, is a tremendous service to the citizens, the parties seeking relief, the parties opposing relief. They can at least know that their matters are going to be prepared and understood as best as can be in advance and given a fair opportunity to be heard and deliberated. And frankly, two of the best authors of opinions are on this panel in the two of you guys. So great job. Keep it up. County's in good hands.
Well, thank you. Thank you. You know, you could start trying to rustle up some clients for zoning matters now, right? Now that you're an expert in this.
Not an expert, but my area remains. I think my only strength is process. Moving along the process.